They do fall under the definition of healthcare provider, and they do fall in this context as it is presented here.
What if the hospital had negligently destroyed some piece of personal property that she had with her? Would that be a healthcare liability claim?
Suppose we would have to go about what type of personal property was it. Let's just say we'll pick one for the sake of argument today, and let's just say it was her pocketbook, right? Something near and dear to one, their pocketbook. So in that instance, we would have to take a look and see, if we look through the different 3 types of healthcare liability claims, does that present some sort of a duty to protect the property of the patient that may fall outside of the context of a healthcare liability claim?
I have designer shoes. When I came here, I don't know where they are. You should have kept an eye on my things.
You know, in looking at that, if you're thinking about, does that trigger perhaps the duties of an ordinary premises owner versus are we triggering the duties of a healthcare provider? That may fall in favor of triggering duties of an ordinary premises owner.
So the second amended petition, is that the live pleading?
It
second
is.
Amended?
It is, Your Honor.
So in paragraph 10, it says, Methodist had a duty to honor the parent-child relationship as codified in the Texas Family Code. What does that mean? I realize I could ask the other side, but you're up, so
sure.
What's going on there?
So the Texas Family Code that's referenced there actually does not present a duty for Methodist in this context. However, what it does say is that a parent may, operative language, a parent may provide a hospital with a release, a written release, to release their child to a third party, including, by the way, it could be Texas CPS, right? And the legislative history of that provision tells us that the purpose behind it was to streamline the adoption process. So as a parent, you may come in and you may say, here is a signed release. You may release my child either to an adoption agency, a third party, or to CPS. And what the statute says is if the hospital or birthing center, because that statute actually applies to a hospital and a birthing center, if you're presented with such a release, you must honor it. There is no dispute in this case. There was no release presented to Methodist. The conduct complained of includes various conduct that is inseparable from the provision of health care in the context of maternal and neonatal care. And one may also be able to argue in the context of the care of minors. But plaintiff alleges not that she presented Methodist with a release and they failed to honor it. That would be their duty under that particular statute. But that Methodist failed to honor the parent-child relationship, that they failed to have a mechanism in place to resolve the disputes between parties that may arise in the context of these sorts of admissions. And the pleading is very telling, because the pleading tells us, as a healthcare provider in the business, regular course of business of delivering and providing labor and delivery care, it should have been foreseeable to Methodist that this type of situation would arise, and they should have had policies and procedures, and they should have had training accordingly.
Which sounds like professional or administrative services.
As per Methodist briefing, if we had to pick from the 3 types, we do think that there's a case to be made for all 3 types of the healthcare liability claims, but it does seem to fit best with the alleged departures from professional administrative services directly related to healthcare.
But wouldn't there need to be a legal determination on to whom to give? I mean, you're talking about, and I understand that, I guess it's probably your side's position that the family code doesn't apply because that's not what happened here. It was sort of the opposite. But how is that not a legal determination being made by Methodist for whom to give the baby to?
So even in the context it's not a legal decision. So let's just take this hypothetical for a moment. Ms. Cagle comes to the hospital, she has the affidavit with her. She doesn't decide to change her mind relative to this affidavit. Methodist moves forward, they reasonably rely on this affidavit, and they, in the context of determining discharge and discharge planning, they release this child to the third party or the intended adoptive parents. That discharge in and of itself is not a legal determination of which parents have the superior right. The affidavit itself and the statutory provisions that govern those types of affidavits say that those decisions, the legal decisions regarding the superior rights, are going to be determined by a family court.
Okay, but is it Methodist's position that Methodist was bound by the affidavit that was signed to give it to the, to give the child to the other adoptive parents?
So Methodist's position in the context of where we are today is that it is within the standard of care when you are providing maternal and neonatal care and you are charged with honoring, and we cited some specific regulations in our briefing, that you're supposed to have a family-centered philosophy, you're supposed to honor the parent-child relationship, that in that context, within the context of the care, treatment, and decisions regarding discharge, healthcare providers have to make a decision. Who is the right person? If you're dealing with, and like I said, this comes up in the context of providing maternal and neonatal care, but one could easily see how it would come up in the context of treatment to minors, treatment to individuals who are incompetent, those who cannot speak their own needs, or have been legally determined incompetent. In order to make decisions, there has to be someone who has the right to make decisions about the care that those types of individuals receive, right? Someone has to consent to that care. During the course of the admission, if more care is needed, there has to be someone who consents. So within the scope of being a healthcare provider and needing to make that determination and needing to know who is the parent legal representative or guardian who is going to be the one that is going to act on this minor or this other individual's behalf who cannot act on their own behalf, that is a decision that has to be made within judgment of a healthcare provider. It's not making a legal decision, but it is a necessary decision that has to be made in the regular course of business of caring for those kinds of patients.
Who would be the right expert? If they're right, alleging departures from the family code, and that's a contested premise, but if that's right, who would be the right kind of expert for that?
You know, there are several types who could qualify as the right types of experts. And of course, I want to make sure to focus the court. There are many other allegations that she has alleged violations of standard of care besides just that one narrow thing. She's also alleging that labor and delivery nurses and administrators failed to follow existing policies and procedures, or Methodist didn't have policies and procedures in place, that Methodist failed to protect this child from the known dangers of third parties. So there are more allegations in addition to that. But taking a view of the scope of expert testimony and the types of experts, it could be a labor and delivery nurse, postpartum nurse, nursery nurse. It could be a hospital social worker. It could be a hospital
social worker. Would that comply with the statute? It would be a medical provider.
They could qualify.
But if they're not currently doing it, what if they have 30 years experience as a hospital administrator, but they no longer work at a hospital? Then that would exclude them.
Certainly, if they do not, really the focus of the statute on qualification is what were you doing at the time of the care alleged, more so than what you're doing now. But if they were not working in that capacity at the time of the care alleged, then they would not qualify. It could be a hospital administrator. It could be anyone who serves on a hospital ethics team. Because certainly when we have disputes, and you know, In the context of, like I said, any admission, neonatal and maternal admission, this is going to come up, but it's particularly going to come up in the context of surrogacy, adoptions, and varying family dynamics, right? Who is the proper individual to make the decisions and then ultimately to discharge this child to? So someone who sits on a hospital medical ethics team, that person could be a physician, that person could be an administrator, but someone who is responsible for working through collaborating in the event that that's necessary in order to resolve these types of disputes. As the group that was here before our argument today, with respect to damages, especially post Gregory versus Chohan, it may be also well advised. You have to have your physician on causation, but I would want to have, it would be well advised to have a physician on damages as well. So those are all the types of experts that one may use. And of course, there's a difference in qualification of the Chapter 70 a little bit, although some of those do apply to your burden of proof phase as well. But in terms of what can you use at the Chapter 74 phase, there's going to be a little bit, there'll be some variance in that regard. However, one thing that is not negotiable, and Scoresby tells us this, is that you have to be an individual with expertise.
Quick question, and it sounds like you would allow a nurse or a social worker to testify, but doesn't section 74351 say it has to be a physician?
On causation.
Just on causation. So if it's not about causation, you would allow some other?
So in the context of the expert report, to qualify on the departures of accepted standard of care for a healthcare provider, you must be a healthcare provider. And then there's also some other things that they look at there, like what is your education, training, experience, what is your certification, those sorts of things. It's a separate provision that talks about what do your qualifications have to be in order to qualify on causation on that particular element, and you do have to be a physician.
Okay, but if it's a departure from accepted standards of care for professional services, not necessarily, you wouldn't necessarily need a physician.
As to, you would absolutely still need a physician to meet statutory requirements for the Chapter 74 expert report, because you have to have a physician on the element of causation.
Okay.
However, to the element of the applicable standard of care and the breach of standard of care, you could satisfy that with a healthcare provider. Now, you could also satisfy it with a physician, right? You could have one physician who talks to applicable standard, talks to breach, and also talks to causation. But on the element of causation, must have.
So if you have a healthcare liability claim, there is no way to avoid the causation element with the physician, right? You agree with that?
That is correct. Chapter 74 says that it must be a report from an individual with expertise that opines as to all of the elements of the healthcare liability claim. So that's going to be the applicable standard of care, the breach of the standard of care, the causation, and the damages. So that's what has to be seen at the Chapter 74 expert report phase. And that's what's missing here. We have a report that was provided. It was provided by Ms. Radcliffe. Ms. Radcliffe is a family law attorney and a former family law judge. She is not a healthcare provider. So we don't meet the Scoresby standard of having a report from an individual with expertise. And then, as pointed out, similar to the Villarreal case, which is cited in Methodist briefing, we have absolutely no report from a physician as to the element of causation. And so, to the extent that there's consideration, a 30-day extension, according to Scoresby, is not available. And Villarreal tells us if you have no report. In Villarreal, what we had there was we had a report from an attorney. And we also had a report from a licensed professional counselor, a healthcare provider. Now, they did not feel like the substance of that report. Their focus there is that it didn't look like it was a report. But the court goes on to say, if we follow Scoresby and we have no report from a physician as to causation, that is fatal. There was no discretion, there's no extension, and mandatory dismissal. And that court reversed and rendered that mandatory dismissal. Got ahead a little bit, jumping towards the expert report issue.
All right, well, but you're out of time, and we're now over 9 minutes over, right? So I'll have to stop you there, and at least that's what I have on my, we don't see the clock ticking up the way you all do, so I keep it on my phone, and I showed 9 minutes, 14 seconds.
And I apologize, I was reading it as going backwards. So when I saw 9, I was thinking 9 more left. I apologize.
Does it say 9 also there? 9,
it does,
9:14-ish?
but I was thinking it was going in the other direction. So.
All right, so that's why I just want to be fair. So we'll give
Thank you.
29 minutes. And then you're welcome, obviously, to come back for your same time for rebuttal, but we just need to make sure that we're being fair.
Thank you. It's an honor and a pleasure to be here. I'm asking the court to affirm the trial court's decision that denied Methodist Hospital's motion to dismiss. This case, I just want to give the core background of facts, because to decide this case, we get to a single moment in time. One single event happened that formed the basis of this case. But we know Miss Cagle was an expectant mother. She checked into Methodist Hospital with the expectations to have a baby. We knew Methodist Hospital would have temporary possession and control of the baby long enough to deliver the baby, get the baby's health into a condition where it could be released and discharged, and then go home. After the time that the baby was born, the baby was treated, the baby was discharged. The hospital said after discharge, it means you are free to take the child home. We have no cause of action yet. A third party shows up and says, I have a superior right to this child over the natural mother. I imagine there was a little bit of time for the hospital to make a decision and go, who gets this child? But Lockhart's the third party. They waived this affidavit of relinquishment. And in a split moment of time, maybe it was a minute, maybe it was 15 minutes, but Methodist Hospital had to make the unilateral decision at one point in time, who has superior right to this child?
Counsel, tell me a little bit about this affidavit. We didn't see it in the record. Do you feel like it was a valid affidavit of relinquishment that the mother intended to revoke, or was it?
My understanding, it was a standard form affidavit of relinquishment, and that comes under the family code. And what the affidavit of relinquishment does is it gives a third party or prospective person to adopt the child, it gives them standing to go file in the family court. It gives them standing to seek a termination and adoption. And so the affidavit, that's what the affidavit of relinquishment does. And so what happens is, when that third party wants to formally have the state recognize the adoption of the child and the termination, they file a proceeding in the family court.
But this was a perfectly duly executed and enforceable affidavit, according to your client?
It wasn't. The family code provides such provisions that that affidavit could be revoked if done in a time period. And what happened is, the Lockharts took the child. My client proceeded pro se, filed a habeas corpus petition by herself. She did it wrong. The court rejected it. Then the Lockharts filed a petition to terminate the parent-child relationship. She went to court pro se by herself, and the family court ruled that that affidavit was revoked. It denied the Lockharts' petition to adopt, and gave the child back to the mother. And then the Lockharts still didn't give her the baby back.
So to recap, it was correctly executed and then revoked.
Yes, it was correctly executed and then correctly revoked in accordance with the law. So the point we're trying to determine when deciding whether this case falls under the MLA or it doesn't, the core set of facts, there is one fact. It's after the child had been discharged from the hospital's care, custody, and control, they made the legal decision who should have the child. Is it mother or is it the Lockharts?
Well, but when they made the decision, the baby was still within the confines, still confined at the hospital. I understand your language that there was no more care being given, no more, the baby was, I guess, deemed healthy enough to be discharged, but and so maybe the concept of discharge had taken place, but the baby was still within the confines of the hospital, correct?
Yes, the child was still within the building, but we got to distinguish between what does it mean to be geographically inside a building and still be under the hospital's care. If you're under the hospital's care, that's prior to a discharge, and then the hospital assumes care, custody, and control and the responsibility for providing treatment. But after discharge, the hospital, discharge means the hospital, we are done providing services. Who's going to take the child home? When it's an adult, the adult just gets in the car and goes home. When it's a child, after discharge, a parent picks up the child and goes home. But the discharge is significant because after the hospital has discharged the child, it really has no more obligation to provide medical or healthcare services. It's just, it's tendering the child to someone who's responsible for the child.
All right, so in my experience as a mother of 3 children, I didn't go pick up my child necessarily. The child was given to me. So in this case, I guess because the adoptive parents or the prospective adoptive parents came in to pick up the child, you're saying that's sort of a different situation where they came in to pick up as opposed to being given the child.
Right, the Lockharts showed up at the hospital to pick up the child and made the representation that we have a superior right to this child over the mother. So this case stems from, was the hospital negligent in not the discharge, not the treatment, but the releasing of a child to a third party over the natural parents in the absence of a written agreement? Because you imagine there's a circumstance where a parent could execute a legal document saying these people are going to adopt the child and you are to release the child to this person. There's probably a circumstance that exists, but in the absence of that, the duty is to tender the child to the parents. And the way if we look at it like this, where a parent releases temporary custody and control of their child to a third party, whether it's a hospital, whether it's a daycare provider, whether it's a babysitter, or whether it's a school, if the release is temporary, is there a duty for that temporary possessor of the child? Is there a duty to return the child to the parent? If there's no duty to return a child to the parent when my possession of that child is temporary, if there's no duty to return the child to the parent, then I lose.
But if there was this duly executed affidavit of relinquishment, why was Methodist not entitled to rely on that? You said that there's a process for revoking the affidavit. And it's in the record, it sounded like what the mother did was just sort of tell someone, I want to revoke the affidavit. Now, and was that enough? Because it sounds like what you said before, that there was a bit more of a process that needed to occur.
That's correct, and that's where we get into the negligence portion. Was it negligent to release the child to the Lockharts in light of this affidavit? And that's where the hospital staff was put into a position where they had to make a legal decision who has superior right and control in light of the affidavit. So when we look at this case to determine, does this fall under the MLA or not? And when we talk about cases under the MLA, we talk about a standard of care. Standard of care is often applied to professionals, doctors. Typically we talk about duty, breach of duty, proximate cause and damages, but in cases involving professionals, we'll use doctors as an example. We talk about standard of care because an ordinary prudent person without the education and skill of a doctor, he can't testify what a reasonable prudent doctor would do under the circumstances because he doesn't have the knowledge and education. For example, should the doctor have taken the person's blood pressure or the temperature or seen if there was infection before doing the surgery? We couldn't testify to that because we're not experts. So when we talk about a standard of care, we're talking about a standard of care that flows from a duty to act reasonable and prudent. So when we apply that standard of care to a doctor, we have another doctor testify and say, this is what a reasonable prudent doctor would do under the circumstances, and talk about maybe the procedure before surgery or this or that. Now when we look at a standard of care and then we contrast that with just a duty imposed by law, I'm telling the court that when a parent drops their child off in the possession of a third party with the intent to return and pick the child up, there is a duty to return the child to the parent. You're not free to discuss whether a parent has a right to that child. You're not free to say, hey, maybe another person has a superior right to the child. Is there a duty to return the child to the parent? We don't have to get into an analysis of what a reasonable, prudent nurse or doctor would do, because the duty at law is to return the child to the parent. So when I say there's a duty in law to return the child to the parent, if we talk about what the source of that duty is, the United States Supreme Court in Troxel said parents have the fundamental right to the care, custody, and control of their child. The Texas Family Code talks about parents make the fundamental decisions, care, custody, and control, direct religious and moral education. When Miss Cagle entered into the hospital, she went there to have a child. She entered into a contract with the hospital. You might say part of the contract is she's going to pay the fees associated with delivering the baby, but implied in that contract is, I'm going to give birth to a child, you will deliver it, and then return the child back to me. I cited in the brief case law that says an implied contract does those things and makes those promises necessarily to fill an obligation imposed by contracts.
So suppose that's true. What about the statute? Why is that not implicating professional or administrative services per the definition of HCLC?
Okay, because the definition of professional administrative services goes towards the medical treatment or the healthcare treatment of a child, and then as it relates to the administrative services, we have to look at the health and safety, things that the hospital does relating to a patient. Examples of that would be in the hospital room, do you keep the room at the right temperature? Are you cleaning the instruments before you use for surgery?
But how does that not apply to, did you discharge the patient to the appropriate guardian?
There's not a safety and administrative service.
Well, even if it's not safety, it's still administrative. You're discharging. That's administrative, right?
Well, there wasn't anything in the administrative code that determines who to release the child to, whether it's a parent or a non-parent. It's not in there. And if it was, well, it's not. It's just not in there. The idea who has a superior right of possession to a child, it derives solely from the Constitution, from the Family Code, and from the implied contract. If you'd ask, what do we need to win this? What would the expert testimony look like if we had a trial? So if they said you could have a social worker, they said you could have a nurse, what testimony could a nurse or a social worker do or provide that would shed any light on who has a superior right of possession? It is purely a legal question.
So what should the hospital do then if they're not sure who has the best legal claim?
Right, and that comes with the negligent training and supervision. What the hospital should have done is you have two people competing for an interest in the child. If they felt like, let's say the parent was endangered the safe, healthy, and well-being, you call CPS. If it was just somebody saying, hey, I have an affidavit of relinquishment, there's no privy between the Lockharts and the hospital. Methodist Hospital owed the Lockharts no duty whatsoever. So as long as that parent is a capable parent, the hospital has a duty to return the child to the parent. If the Lockharts believe that this affidavit of relinquishment gives them a superior right, they should take it to the family court, because surely Methodist Hospital is not bound by an affidavit of relinquishment where it's not a party to the agreement. It's only bound by their implied contract, their implied agreement that when a mother checks into the hospital to give birth, it's implied contract that they will return the child to the mother or to the father when the release of discharge occurs.
Do you agree with the opposing counsel if the petition states a mix of healthcare claims and non-healthcare claims or allegations, that everything is converted to a healthcare claim?
No. In the common law, there's always room for to make a distinguishment. For example, one of our claims says the hospital had a duty to release the child or to return the child to a mom. That's not a healthcare liability claim. If this court could see fit to enter a ruling saying there is a duty for a temporary conservator or possessor of a child to return it to the parent, if this court finds that duty, that's a duty, that's all we need. But when it comes to training and hiring and supervising personnel, whether the hospital was negligent in their supervision, okay, now that goes beyond a simple decision making. That goes to, we need to write a policy as to how do we handle a situation like this. But then again, those policies would be written by lawyers.
Okay, but following up on Justice Gunn's question, we have a Texas Supreme Court precedent, Collin Creek Assisted Living Center versus Faber, which says if you have a mixed issue and there's if there's a cause of action from one type of standard, such as safety or administrative services, and it's mixed with a different issue, then you have a healthcare liability claim. What do you do with that?
But that claim would have to be, this claim would be distinguished between that, because would be a fundamental concept at law, because this court could simply say and recognize there's a duty to return the child to a parent, as opposed to how to train staff. While it flows from one core set of facts, the duty to train a staff in the legal consequences of their actions, or which party has a legal right to possess a child, okay, that could require expert testimony that might even fall under the MLA if they could tie a provision to that, because even for the MLA to provide, they still need to connect it to the medical treatment, which there's no medical treatment up for grabs here. We're only complaining of a mental injury. We would need to combine it with a healthcare service. After the child was discharged from the hospital, there were no more healthcare services provided, or administrative services. There's no administrative services implicated here. There's only the legal decision, who has a superior right of possession, and does the hospital owe a duty to return the child to a mom. The thing is, if we make some sort of rule that says mom's right to possession or access to her child, you need an expert to come testify in court, that turns upside down the fundamental precedent set by the Supreme Court. It turns upside down provisions in the family code to say, in order for mom to come forward and come to court saying, I have a right to possession, and if you give my child away to a third party, I need an expert to testify. That literally turns upside down precedent case law, establishing the fundamental relationship between the mom and the child, it would have turned upside down the implied agreements that when Miss Cagle came into the hospital to say, I'm here to have a baby, but now the hospital's not bound to give mom back her baby?
Why is that true? Why does that in any way abrogate whatever duty you're asserting? It seems to me those could be completely compatible. It just means you got to get an expert to get into court to vindicate that duty.
Well, the expert you wouldn't need an expert if the duty that you find says a hospital must return a hospital temporary possessor of the child must return the child to the mom as a common law duty recognizing the parental rights. Once that duty is established by the court, or that obligation, you don't need to talk about a standard of care, as applied to what a professional doctor would do or a nurse would do, because your duty, as you write it, is simply says, under this circumstance, this is what needs to happen.
I don't understand. If that's true, why can't you get an expert who would just say that?
Well, we had an expert. Suzanne Radcliffe is a lawyer. She filed an expert report. She pointed out provisions in the Family Code, the United States Supreme Court, that says mom has a superior right of possession to anybody else.
So look, there's two states of the world here. There's one state of the world in which you don't have a healthcare liability claim, in which case you don't need an expert report by a physician. But if we do have a healthcare liability claim, then the statute clearly says you need an expert to come from someone practicing healthcare, which an attorney does not. So is your argument that this is not a healthcare liability claim, you didn't need an expert, or that your expert was fine?
My argument was primarily to the trial court that we did not require an expert, because the decisions that had to be made was one decision: who had a superior right of possession, as opposed to what the hospital did with the child. It solely comes from making a legal decision as to who had a superior right, and the only person that could testify to that would be a lawyer. I mean, when opposing counsel made the argument you can have the social worker testify, what qualification would a social worker have to tell the hospital who should have possession of a child?
So you agree that this expert report isn't compliant with Section 7?
The expert report is in compliance, and since the injuries that are complained of arise from the loss of companionship of mother being with child, the injury complained of doesn't relate to a doctor delivering the child. It doesn't relate to the nurse's care. The injury complained of is just the mental anguish that accompanies a mother from not having possession of her child for a year and a half. So the injury here complained of is not a physical injury where we need to talk about the causation of the doctor or the nurse. The injury, because if the doctor or the nurse does something wrong and the child is born with a deformity or a leg or a disease or something like that, this injury is solely related to mom's loss of companionship from the child, which is, even by an ordinary prudent person, could understand and say that person has been injured because they didn't have possession of their newborn child for a year and a half. Because it doesn't relate to the medical service or the healthcare services. For example, here's the easiest example. If they want to say, you didn't take care of my property, let's say the nurse, you left your purse there, and the hospital has its own procedures for handling stuff that's left there. Feasibly, a hospital, they didn't deny it, that could fall under a healthcare liability claim because they took possession of the purse, and there's administrative code saying what you do with the purse. Well, if the purse had $500 in it or the purse was worth $2,000, I don't need a doctor to testify to the value of the purse. It speaks for itself. The injury here just speaks for itself.
Are you familiar with the Christus Bond versus High case out of the 13th Court of Appeals? I know it's not binding on our court, but it seems very analogous to this situation.
I do think I read it, but I don't remember the exact contents of it.
So this is where two babies were switched and given to the wrong families.
Yes.
And this was, it's not clear how many years went by, but obviously one of the children was old enough to get a DNA test and learned that she was not
No,
related to
you're
her
right.
own family, and that court held that that was healthcare liability claim.
And that is distinguished from this case because the issue in that case had to do with the identification process of identifying children that go with a specific parent. So it was the procedures that the hospital implemented for identifying it, and I don't want to say tagging children like they're animals, but for the most part, it was their procedures that were implicated for identifying that this child goes with this parent and this child goes with this parent. And so their procedures were attacked saying, hey, you were negligent. And then all of a sudden when it talked to what procedures had to be, were the flaw in the hospital's procedures, you needed an expert to come in and say, a reasonably prudent doctor or hospital would have done these procedures to protect the child going with the right parent. But that's not the case here.
How is it not? And isn't that one of the claims made in the petition that the failure to train or have procedures in place to make sure that this child went to the legally correct person?
The procedures that I would be referencing would say the procedure is when a mom gives birth to a child, her right of possession is superior to everybody else's. If there is a conflict, then it was a legal decision to call the Texas Department of Children and Protective Services. It wouldn't have to do with medical procedures, it would have to do with legal procedures on how to handle a conflict when two people are asserting superior rights to the child. This entire case has to do with not the medical procedures, not the healthcare procedures, but the staff for Methodist Hospital. They were put in a position where they had to make the legal decision who had superior right to the child. They should not have been put in that position. If they had a procedure, it should have been a procedure. You call our lawyer, or you call the Texas Department of Protective and Family Services. But that really wasn't the case here, because what the staff was confronted with, a third party who had no privity with the hospital said, I have a superior right to this child. And so it wasn't a case where medical procedures with the identification, it was solely a legal question as who had a superior right. This case is about parental rights of the child over a non-parental rights when that child is placed in the care of the third entity. We could be standing here having this same oral argument if a daycare released the child to a third party. Somebody could come in and say, I have an affidavit of relinquishment, and the daycare could release the child to the third party, and we'd have the same lawsuit, only the court would say, okay, this doesn't apply, the Chapter 74 doesn't apply, but the same thing would have happened, and the same rule of law would have controlled. Then their rule is whether a third party in possession, in temporary possession of a child, does that party have a duty to return the child to the parent?
Yeah, I'm willing to assume the duty element in your favor, because I don't think that's teed up here. I think it's just a question of, is it covered by the statute? The duty issue, what I hear you arguing is there's a negligence duty not to inflict emotional distress. And generally that's not true. But I don't see that as being here. I see this just as statutory slip. And I hear you. Could you speak to
Yes.
the 30-day issue of, if you need an expert to get an extension of time and go get a report on file?
Yes, the law is clear that where a party files an expert report, if the expert report is deficient and it's curable, the court has a mandatory duty to give you 30 days to remedy the defect. But the rule is, if it can be remedied, then dismissal is improper. And here, they're complaining about the qualifications of Suzanne Radcliffe. And if it's a matter of getting a different expert, then that's curable.
Okay, but you have to pass the good faith test in order to get an opportunity to correct. So, the statute says practicing healthcare, there's an expert report from someone who's not practicing healthcare. Make the argument that it was a good faith effort.
Well, the good faith effort, Justice, was this whole case is premised upon a legal duty as to who has the right of control or has the right of possession and access. The question presented in the petition was who had a right of access. None of the complaints in here demonstrated a physical injury resulting from the birth, the delivery, or any administrative services from the child. So we did hire an expert. That expert wrote a report that said this person is qualified, or this person had a superior right, and the mom suffered an injury because of the absence, because she didn't get to possess her child. And so there's no statutory guideline to say this particular expert is needed for this, when there's no statutory said on this type of claim you need somebody with this type of qualifications. And if we talk about what type of qualifications an expert would need, what would the jury charge look like? I don't think we would be getting very far into whether the hospital should release a child to a mother over a non-party. What type of testimony could somebody else other than a lawyer offer? A reasonable, prudent hospital would have procedures? That's a question that seems like it would be something for the judge to say, that there's a duty to return the child to the mother. I don't see an expert coming in and saying something different. I don't think there could be a provision in the administrative code that would negate mom's right to possess her child. There'd be no authority in the history of our jurisprudence that would say somebody else other than mother has a superior right of possession. So when we talk about what type of experts in good faith, we were presented the hospital's negligence arose out of their legal decision. We got a lawyer to discuss, a lawyer to opine what the legal duties of a hospital is. I think there's a difference here between, not all decisions are medical decisions. Not all decisions go to the health and the safety. Some of the decisions a hospital has to make are purely legal decisions. This was a decision that was purely a legal decision. It just wasn't a medical decision. It didn't involve identification. It didn't involve blood or testing. It didn't involve anything that relates to health care. It just says, I'm mom, I deserve my baby back. And that's why we believe it doesn't need to fall. If this court would fashion and come to a ruling as to whether a hospital has a duty to return the child to mom, I think if you find that it doesn't, okay, I'm going to lose the case. But if you find that the hospital, implicit in their agreement with Ms. Cagle when she came to the hospital, implicit in their agreement is the duty to return the child to mom, then no expert, and it doesn't even fall under the MLA. If you find conversely, I would really be interested to see what that law says, because that would turn upside down various jurisprudence that forms the history of this country. This case, the MLA was designed to weed out and expedite frivolous lawsuits. Mom lost her child for a year and a half because of the decision-making of the administrative staff, that somebody else. There's nothing frivolous about that. Her injuries were real. They don't require, because it's not a physical injury, because she didn't go to the hospital complaining of a mental injury. This was the mental anguish, the loss of companionship. It didn't flow from the medical treatment.
Yeah, I don't think we quarrel with that. I don't anticipate we quarrel with your duty paradigm here. But what you just said, those two words, administrative staff, that's what concerns me, is the definition, the word professional administrative services. That's what we're concerned about.
The administrative services must relate to the physical safety and health of the child as it relates to, and it has to relate to the medical or healthcare services. So the administrative services of that part of Chapter 74, it must be tied in to the medical services provided or the healthcare services. It's not tied into it because the child had been discharged. At the end of the discharge, what is there left for the hospital to do? there's no obligation of the hospital except give the child back to mom.
Thank you.
Thank you, Justice.
Briefly in rebuttal, there's been some great liberty taken here with respect to the content of the affidavit of voluntary relinquishment of parental rights. And so in following suit on that, it is worth noting that it was required on its face to be revoked in writing, and there has been no allegation that it was revoked in writing. Her petition clearly says that she confided in those who were caring for her that she wanted to revoke it, and that she did not want them to tender her child. Methodist would also take exception with the idea that there was only one single event that makes the basis of this case. The petition clearly outlines multiple events. Number one, Methodist did not deliver the child to her. In other words, at the time during the confinement when she had this baby, they did not deliver the child to her. Moreover, there are allegations that she was deprived of her natural rights as a parent during the confinement. We can see that in the petition as well as we can see that in the record. We also can see, and it is important to note, that decisions regarding discharge have to be made prior to discharge. They have to be made prior to the conclusion of the confinement. And to the extent that there was a statement that this wouldn't include identifying to whom we might discharge this child, talking about that Christus Spahn case, well, absolutely, that's something that would need to be done during the confinement itself, during the course of making the discharge decision. With respect to implicated regulations, at the time, Methodist was licensed hospital pursuant to the Texas Administrative Code, and it was also carried a level of care designation for maternal and neonatal care. As such, it was required to follow various regulations that don't apply to standard reasonable people. They don't apply to the ordinary premise owner, and they don't apply to babysitters.
Could
Would
you
you
tell us
agree?
what those are?
Yes, be glad to.
Well, I was going to say, would you agree that they don't specify discharging a newborn child in them?
They do specify, well, this includes the Texas Administrative Code provisions relative to patient rights, which do specify that to the extent that ethical issues arise during the care, the hospital must have a mechanism in place to address those ethical issues. And that is in part, one of the allegations being made in this case is that Methodist failed to have policies and procedures in place to deal with this dispute, this ethical issue that arose during her care.
Where do we find those administrative provisions?
You may find those under the Texas Administrative Code 133.42. They're also outlined in Methodist's briefing. In addition, as a leveled entity, it must follow the program requirements in the Texas Administrative Code 133.185 and 133.205, and that includes, in follow-up to what Mr. Gross said, that it should have just been evident that the mother would have the superior rights. It says here that part of their requirements is that they must have a family-centered philosophy, and a parent must have reasonable access to their infants at all times and be encouraged to participate in their care. And the facility must meet the needs, the physiologic and psychosocial needs of mothers, infants, and families. And that is yet another reference. To the extent of the need for expert testimony, the reasonable person doesn't know what a hospital is supposed to do or not do relative to policies and procedures and training to ensure that they meet these various regulations that some cited today and additional ones cited in the briefing. Mrs. Cagle sought specialized neonatal maternal care. That's going to require specialized testimony with respect to the standard of care of what they should have done. And that's all of the allegations in here. There's also the allegation that they failed to make safe from a third party. And there are also regulations in that regard, that being Texas Health and Safety Code 2410263, that the hospital is required to put mechanisms in place to reduce the likelihood of infant abduction, which is essentially tantamount to what the argument is here today, is that the intended adoptive family showed up and they failed to make safe known dangers, the hospital did, and they essentially abducted this child. So those are some various regulations that have been implicated in addition to the patient rights, which we talked about, and then there's also, well, I mentioned it, the care, access, and protection from the dangers of third parties. Implicated are duties of the healthcare provider, not any standard person and not any regular property owner.
So what about their argument that this could be a daycare center that hands over a child to the wrong person?
So these regulations that I have mentioned don't apply to daycare centers. They apply to hospitals that are licensed pursuant to the Texas Administrative Code, those that are leveled pursuant to the level of care designations for maternal and neonatal care. So they don't apply. And then that's in addition if we were focusing on the departure of professional services, professional administrative services directly related to healthcare, which, by the way, they only need to be directly related to healthcare. And this case is right on point with this court's decision in Ramos. Cagle was admitted to deliver her child. That patient was admitted for a dilation and curettage. In the course of that, the hospital came into control of products of conception or fetal products. Here, the hospital came into control, temporary that being, of this child. Subsequent to coming into control of that, hospital and Ramos disposed of it. They claimed negligently. Same allegations that are being made here. They disposed of this child or discharged this child in a negligent manner. But clearly, her petition says she suffered damages during the admission, and then she says, and they continued after discharge. So at just one point in time is not the case. Lastly, on that point, Methodist would say that the care involved here, the allegations involved here, are not so far removed from healthcare that they are analytically separate. This is a healthcare liability claim. To the extent that there are statutory guidelines, there are statutory guidelines for expert reports. They're in Chapter 74. The minimum standard is in Scoresby. The report, if we look closely, first and foremost, she's not a healthcare provider, so she doesn't qualify, but if we look closely, she says, I'm not here to talk about the standard of care for medical care. And she goes on to say, here's what Methodist Hospital should have done, that's what a reasonable person would have done, and that's what a non-lawyer would have done. That's not the appropriate standard of care. And then lastly, without a report from a physician on causation, that is not curable. There is no 30-day extension allowed. Thank you for the court's time, and we would respectfully request that the court reverse and render.
Thank you both for your arguments. This court is adjourned.
All right. Chair.